Hello and welcome to the Minimum Competence episode for Wednesday, June 25th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, a same-sex marriage challenge at the Supreme Court, a fair use win for Anthropic in AI training, and a bail hearing for wrongly deported Kilmar Abrego Garcia. Let's remember, the death of democracy is not likely to be an assassination from ambush. It will be a slow extinction from apathy, indifference, and undernourishment. And read today's legal news. On this day in legal history, June 25th, 1798, the United States Congress passed the Alien Act, one of the four laws collectively known as the Alien and Sedition Acts. Signed into law by President John Adams, the Alien Act authorized the president to order the deportation of any non-citizen deemed, quote, dangerous to the peace and safety of the United States. This law emerged during a time of heightened political tension and fear of foreign influence, particularly as hostilities with France escalated during the Quasi-War. The Federalist-controlled government promoted the act as a necessary measure to protect national security, but it quickly drew criticism from the rival Democratic-Republican Party. Critics argued the act violated fundamental principles of due process and civil liberties, granting the executive branch unchecked power over immigration and expulsion. The law did not require a criminal conviction or even a hearing, allowing deportation based solely on presidential discretion. Although the Alien Act had a 2-year sunset clause and was never directly enforced through mass deportations, its passage contributed to a growing divide between Federalists and Jeffersonians. The broader set of Alien and Sedition Acts also targeted political dissent, with the Sedition Act criminalizing speech critical of the government. These laws played a central role in the 1800 presidential election, fueling opposition that ultimately helped Thomas Jefferson defeat John Adams. In the long run, the Alien Act became emblematic of federal overreach and was widely viewed as an overreaction to perceived threats. It underscored early challenges in balancing national security with individual rights and helped lay the groundwork for later debates on immigration and executive authority. A decade after the Supreme Court's landmark ruling in Obergefell v. Hodges, a Christian legal group is preparing to challenge the decision that legalized same-sex marriage nationwide. The move comes amid broader conservative momentum, including a Southern Baptist Convention resolution calling for the ruling's repeal and a recent Supreme Court decision upholding Tennessee's ban on gender-affirming care for minors. Despite these developments, legal experts, including conservatives, see little chance the court will take up the challenge. John Birch, a former Obergefell litigator, noted that overturning such a major precedent typically requires both time and significant public advocacy. Roe v. Wade, for instance, remained in force for nearly 50 years before being overturned in Dobbs. Nonetheless, Liberty Counsel is moving forward with a Supreme Court appeal on behalf of Kim Davis, the Kentucky clerk who refused to issue a marriage license to a same-sex couple just days after Obergefell. Davis was found liable for $100,000 in emotional distress damages, and the group will argue that her actions were protected by the First Amendment. The Sixth Circuit rejected that argument, stating that Davis acted as a public official and thus could not claim constitutional protection for her refusal. Liberty Counsel also intends to ask the court to reconsider the core ruling in Obergefell, comparing their strategy to how Dobbs upended abortion rights. Legal observers remain skeptical. The Supreme Court already declined to hear Davis's earlier appeal, and while Justices Clarence Thomas and Samuel Alito expressed concerns about the scope of Obergefell, they said Davis had not properly raised the issue in lower courts. The procedural misstep could again doom her case. Meanwhile, political efforts are mounting in conservative states with resolutions and bills promoting, quote, covenant marriage that excludes same-sex couples. Still, critics such as the ACLU see these moves as largely symbolic and lacking real legal traction. A new ruling in the case Bartz et al. V. Anthropic BPC has provided the first major legal decision on whether training generative AI models qualifies as fair use under U.S. copyright law. District Judge William Alsop concluded that using legitimately purchased books to train AI models like Anthropic's Claude counts as transformative fair use as long as the books are bought for training and then destroyed afterward. This decision gives AI developers a tentative legal framework or roadmap for creating compliant large language models, though the ruling is not without limits. Alsop allowed separate claims involving pirated training materials to proceed to trial, drawing a sharp line between lawful acquisition and copyright infringement. The court's ruling highlights the four traditional fair use factors, placing significant weight on the transformative nature of AI training while minimizing the importance of its commercial impact on the original market. Alsop asserted that the use was transformative enough to outweigh concerns over licensing markets, suggesting that AI training doesn't necessarily harm authors' ability to profit from their work. This view diverges from recent interpretations emphasizing market harm, such as the Supreme Court's 2022 Warhol decision. While this reasoning favors developers, it also creates tension with copyright owners who argue the ruling downplays existing licensing practices. The decision notably distances itself from claims involving pirated materials. Alsop treated the copying and use of pirated books as a separate issue that may still result in substantial liability, including statutory damages. This split decision, approving the use of lawfully acquired materials but scrutinizing pirated content, offers a compromise approach the courts in similar cases might adopt. With multiple lawsuits against OpenAI and Meta pending, ALSUP's ruling could influence upcoming decisions, though judges in other districts may interpret the law differently. The opinion suggests that training can be transformative and lawful under certain conditions, but reinforces that AI companies must source training data responsibly. Gilmar Abrego Garcia, a Salvadoran national previously deported under the Trump administration despite a court order barring his removal, is set to appear in a Nashville court to determine the terms of his release from jail. A U.S. magistrate judge ruled that Abrego could not be detained pending trial, citing insufficient evidence that he poses any danger. Abrego has pleaded not guilty to charges of conspiring to smuggle migrants into the U.S., accusations his legal team argues were intended to justify his unlawful deportation. His case has drawn attention as a symbol of the Trump administration's controversial immigration policies and has sparked civil rights concerns. The court noted that even if Abrego is released from criminal custody, immigration authorities may still detain him. The judge questioned the reliability of the government's witnesses, many of whom are convicted smugglers or deportees seeking leniency. Prosecutors allege Abrego transported migrants, including minors, on over 100 trips between Texas and Maryland, often accompanied by his own children to avoid suspicion. However, the court viewed these claims skeptically due to the witnesses' motivations and their own criminal backgrounds. U.S. officials initially labeled his deportation as an administrative error and resisted calls to return him, raising further due process concerns. Another judge is investigating whether the administration violated court orders related to his removal. Ultimately, the Justice Department brought Abrego back to face charges, but the judge's recent ruling underscores the court's commitment to ensuring his constitutional rights are respected. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the people never give up their liberties, but under some delusion.